and I can't find a seconder usually when I propose this, but I don't care. I don't need a seconder. My own opinion is enough for me, and I claim the right to have it defended against any consensus, any majority, anywhere, any place, any time. And if anyone disagrees with this can pick a number, get online, and kiss my ass.
No representation is made that the quality of legal services to be performed are greater than the legal services provided by other lawyers. I'm Harry Steele. You found the Backstory Podcast, number 104. Have Mr. Ripp of the Ripp Report in studio with me today. How are you, Mr. Ripp?
Glad to be here. A little dreary today.
And y'all had some show enough weather out there in Houston, didn't you?
Yeah, we had a little bit of blow move through, but that's, on par for the 88-degree, balmy October days of Houston, Texas.
Right. No more, when are we going to have 50s again, Mr. Ripp? 3 weeks from now?
Probably
Yeah.
pretty close.
It's just muggy, typical Alabama around here.
Fall.
Well, we're going to do something a little different today. Mr. Ripp's going to do his Ripp Report, and then we're going to talk about the case that's going to be teed up tomorrow morning. And we thought we were going to be in court until Thursday when we were notified it was going to be a virtual hearing. So we'll be sitting right here tomorrow for that.
Yeah, and I was a little disappointed. I wanted to go to court personally. I like to be up front and see who I'm talking to and everything.
And I like to interrupt my opponents.
Right. I hate it's virtual. But this is a test. That's the title of the Ripp Report, rippreport.com, or on Facebook. This week, I encourage you to go read it. The Ripp Report's a consumer organization. We maintain a blog site, Facebook sites, and, of course, this podcast. We're not-for-profit, and we expose political corruption and file the appropriate complaints with political corruption, and that's kind of led to where we are now. On Monday, like Harry said, it's instead of going to court, we're going to be virtual on the 25th, Monday, with Judge Hardwick, Circuit Court Judge Montgomery County, and he's going to hear a status review and all the pending motions relative to the writ of mandamus that I filed on the 18th. Simplest way to explain this without getting into a bunch of legal jargon is that this is a test. This is a test of the state's ethics and the state's elected officials do their job. Any citizen should be able to file a complaint against an elected official, lawyer, or judge and have the expectation of justice, not in Alabama. Alabama citizens have had many options to file complaints. The governor, ethics commissioner, attorney general, bar association, judiciary, and district attorney. But what do you do if you can't get past that, if nobody does anything? That's what's bringing us to this writ of mandamus. We're asking that the ethics commission do what they're supposed to do. We filed complaints with all of the above that I just mentioned, and then and that's been since the revelation of the executive director of the Ethics Commission, Tom Albritton, who was self-dealing the Mabel Amos Memorial Fund, and Mr. Albritton's doing the very act which is basic corruption, self-dealing, enriching oneself via the public position that they hold. And what should be mentioned here, too, is that these aren't allegations. These are things that Mr. Albritton admitted to in the articles that Rob Holbert wrote with the Lanyap. And in the rippreport.com, you'll see those links will be in there. You can get on them and find out a little bit more about it. And you'd think that the media would be all over a story like this, like a dog in heat, but so far the Ethics Commission and Bar Association sees no problem with Mr. Albritton receiving more than $120,000 for his children's education from the trust that he is a trustee. And the absurdity of the justifications of Mr. Albritton by the Ethics Commission and the Bar Association further exposes the depth of the corruption. And as I said, Lanyap, Rob Holbert, broke this story, and the media, for some reason, just hasn't picked it up yet. And I just don't understand that, because, when we had Hubbard, all of the hullabaloo about Mike Hubbard, well, this is just as egregious. And not only did Mr. Albritton take some money out for himself and his partners, but he also had a partner, County Circuit Judge Ben Bowden, and that's in Covington County. And between 2014 and 2017, he benefited to the tune of $45,000. So you should be able to smell something going wrong there. This writ of mandamus is our next step as to where we can go with this, trying to seek a little bit of justice. One of the main reasons that this is filed, too, is that Mr. Albritton is doing the very same thing that we have made 3 previous complaints on. And now we see that, he's overseeing complaints that we're sending up there that he's doing himself. So no wonder we never got any satisfaction that way. Even with the writ of mandamus, people say, well, I guess that's the end of that. No, believe it or not, you've got other options. You've got IRS, federal court, FBI, banking commission, or a civil suit. Now, we know that there's a civil suit coming down on this to Regions Bank, we're pretty sure, very soon. And whoever is the beneficiaries of that trust is probably going to read like the who's who of Andalusia and Connecticut County, so we'll see what's happening. The most interesting part about this whole story in the Mabel Amos Memorial Fund is that on the land, a well known as 36-3, Amos 36-3, which was land leased from the Mabel Amos Memorial Fund, produced $70 million to $80 million worth of oil and gas, and has a potential of another $20 million. And even after 20 years, this was discovered in 2010, even after 10 years, it's producing 100 barrels a day. So how in the world did all of Connecticut County, the county commissioners, and no one know that this was going on? We know that the trustees, we know how they've benefited. We know how the bank has benefited. How has the Connecticut County benefited? How have those people benefited? Now, as I said, the option next is to maybe go to federal court, and another case that we have is very parallel to that is the Baldwin County Family Court with Judge Michelle Thomason. And some of you have been following our podcast know that there's a lawsuit right now, and it's headed to federal court, and it's contesting the fact that Judge Thomason is acting in the capacity of a circuit court judge when she was actually elected to a district judge. However, she wouldn't do a better job at either judgeship. Anyway, that's a comparison, another federal case that's moving along. I don't know where this is going. Harry, I guess we'll see tomorrow morning, but I can tell you it's not anywhere close to being over with as far as I'm concerned.
So, Mr. Ripp, here on the screen, we're looking at a letter that Governor Ivey wrote to you, or right. Brian Taylor did,
right?
The general counsel, and without going into a whole lot of detail, I think the hilarious part of this is they said, we're going to follow up and send all this over to Tom Albritton, the director of the Ethics Commission.
Right. This is the same Tom Albritton that we're talking about now. And that particular case, was Councilman Robert Brown. He's not a councilman anymore. And the contracts that he got while he was on the board of the Fairhope Art Museum.
Yeah, we'll get there. So here's a copy, an actual screenshot of our amended petition for a writ of mandamus. And, of course, the Ethics Commission members are Beverly Brady, John Plunk, former Chief Justice Lynn Stewart, Stanton McDonald, and did you know that Edward Cromwell was a retired general?
Yes.
Yeah, so they're all appointed officials charged with investigating alleged breaches of the Alabama ethics law. Thomas A. Albritton, who you've just been hearing about from Mr. Ripp, is the director of the Alabama Ethics Commission. The Alabama Ethics Commission is located at 100 North Union Street in Montgomery, Alabama, and that is why we are in front of a circuit judge in Montgomery. because of where they're located. We had to sue them there. So the issues, the director of the Alabama Ethics Commission, who directs the day-to-day work of the commission staff, is also an attorney. Prior to becoming director, he was appointed as one of the 3 trustees that administers the Mabel Amos Memorial Fund, a scholarship trust created by her will, which also demands that 2 members of Albritton's law firm in Andalusia, Alabama, sit as trustees. Alabama State Ethics Commission Director Tom Albritton continues to serve as a trustee on that board. The trust document has 2 simple ethical provisions. The trustee shall not engage in any self-dealing as defined in Section 4941D and shall not make any taxable expenditures as defined in Section 5489, referring to the IRS code. Director Albritton's children receive scholarships from the Mabel Amos Memorial Fund in violation of these 2 sections. Allegations. Director Thomas Albritton has stated publicly that he abstained from any votes relating to scholarships awarded to his children. This does little to negate the violation of the trust related to the Internal Revenue Code sections. Mr. Ripp has filed complaints with the Ethics Commission whereby the alleged ethics violators did the exact same thing, abstained from casting a vote on the matter. The specific complaints are the Fairhope Airport Authority board members Jack Burrell and Ray Hicks Jr. related to the lease of real property at said airport. Mr. Hicks' development business partner is the Fairhope Municipal Judge Haim Snedeker. Jack Burrell also serves as the City Council President of the City of Fairhope, which appointed Mr. Hicks to the Airport Authority and Mr. Snedeker to the bench. B. North Baldwin Utilities board members Robert A. Bob Wills and James Robertson related to the purchase of 2 houses at Steelwood Country Club in Loxley, Alabama, from a trust where Mr. James Robertson serves as the trustee of said trust, and Robert A. Bob Wills, who's also the mayor of Bay Minette and an attorney, is a beneficiary of the trust. The trust was established by the mayor's father-in-law.
Boy, that's all convenient, isn't it?
And then the third case that Mr. Ripp had made a complaint about was the Fairhope City Councilman Robert Brown related to a no-bid construction contract with the Eastern Shore Arts Council, where he serves on the board as a liaison to the City Council. Had it not been for his position on the Fairhope City Council, he would never have been on the Eastern Shore Arts Council board to create said conflict.
Correct.
And here's where we get into the law. The Alabama Supreme Court and the Court of Civil Appeals have been very clear that the writ sought is an extraordinary remedy, and therefore there must be a clear showing of several things. The first is a clear legal right in the petitioner to the order sought. So all you're asking for is for them to do their jobs, right?
Correct.
Okay. So and you feel like as a citizen taxpayer that they ought to?
Correct, and as a consumer association.
So number 2, an imperative duty upon the respondent to perform, accompanied by a refusal to do so. So in the pleadings that we had to file 7 days prior to this hearing,
right?
That was part of what I sent back to them. Was a copy of your complaints in all 3 cases,
correct,
and a response from them saying we're dismissing this. So the lack of another adequate remedy. So while you may have lollipop visions of going to federal court with this thing, I really don't know how. So
I've been told that before.
It's limited jurisdiction and scope. Well, I mean, if they're violating your civil rights by not doing their job, then you'd have an action in federal court.
Right.
But not under this scenario. So lack of another adequate remedy. Who else can you go to, Mr. Ripp, and say Mr. Albritton and the Ethics Commission aren't doing their jobs? Nobody.
FBI, IRS,
okay,
Banking Commission.
Maybe you're misunderstanding me. In
no,
the legal process,
No.
what can you do? This is your last legal remedy
This is it.
under Alabama law.
This is a test.
So, number 4, properly invoke jurisdiction of the court, and that's why I was telling you that we filed it here in Montgomery County. And there's several cases there that I quote that tell the court why it has jurisdiction. Because it's an extraordinary remedy, the standard of review is whether there has been a clear abuse of discretion, and this is by the trial court or just in its place, say, the agency involved.
Right.
And the clear legal right, the plaintiff alleges that the director of the Alabama Ethics Commission disregarded complaints filed by the plaintiff over his tenure. As a citizen taxpayer, Mr. Ripp has a right to have his ethics complaints evaluated and investigated for these alleged violations of state ethics laws. The Code of Alabama, Section 3625.5, demands that the Ethics Commission to investigate any personal use of office, and specifically Section 3625.4 sub 7 states, make investigations with respect and upon complaint by an individual with respect to alleged violations of any part of this chapter to the extent authorized by law. That's pretty damn specific.
I think so.
Plaintiff believes these complaints were dismissed without investigation at the direction of the director of the Alabama Ethics Commission, Thomas Albritton, where the alleged bad actors, quote, abstain from voting on the matter, which is, of course, his defense to the allegation that, hey, you gave your kids a bunch of scholarship money when you were supposed to be a trustee.
Right.
And his defense is, I abstain from voting on the matter. Number 11, lack of another adequate remedy. The plaintiff alleges that the writ is his only recourse. All alleged ethical violations were filed per Code of Alabama 3625.4. The commission did nothing. Because of this inexplicable lack of investigation into the allegations that the plaintiff has made over many years, Mr. Ripp demands that the Ethics Commission perform the duties directed by the Code of Alabama. Because of the limited and exclusive jurisdiction of the Ethics Commission, the plaintiff is unaware of another remedy at his disposal. When a writ of mandamus is sought, there must be an imperative duty upon the respondent to perform, accompanied by a refusal to do so. The plaintiff filed the appropriate applications, notarized and timely. The Alabama Ethics Commission did not investigate these allegations. They sent notice to the plaintiff that the matters were closed. Jurisdiction of the court. The Circuit Civil Court of Montgomery County, Alabama, is the appropriate jurisdiction of this matter of state law and the enforcement thereof by state officials, and this court has proper venue jurisdiction as the Alabama Ethics Commission that is located in Montgomery, Alabama. Therefore, the premises considered, we want them to reevaluate. So, did I do a good job of explaining the writ of mandamus, Raines?
Yes.
All right.
Here's the other thing. We have a pessimistic expectation as to what's going to happen tomorrow. They could just, get into it 5 minutes and say, hey, we're not going any further, the hell with it. Click. Done.
Well, so let's look at their motion to dismiss.
All right.
And it'll kind of give you what we're up against here. So come now the defendants pursuant to the Alabama Rules of Civil Procedure Rule 12B. And anyone who's a lawyer can tell you a Rule 12B motion are a dime a dozen. And move this court to dismiss the petition for writ of mandamus for a lack of subject matter jurisdiction and for a failure to state a claim upon which relief can be granted. In support of this motion, the defendants offered the following. Number one, the court lacked subject matter jurisdiction to issue a writ of mandamus directing the Alabama Ethics Commission to reopen complaints that have already been considered and dismissed by the commission, either with or without the involvement of the director of the Ethics Commission. If the court were to issue such a directive, it would violate the separation of powers clause of the Alabama Constitution.
Uh-huh.
Okay. So
here we go.
Let me go ahead and break that one down for you. We have three branches of government. The legislature makes decisions about how money gets spent. The executive runs the apparatus of the state and directs public employees. And then the judiciary calls balls and strikes on whether or not what they're doing is legal or not, right?
Right.
So we have separation. So when I was the county manager up in Etowah County, the sheriff there filed a writ of mandamus against me and the county commission. And he said, Judge, they're not giving me enough money. And one of our arguments was a separation of powers. The judge can't supplant what he thinks the county commission ought to be spending on the sheriff's department. You understand that, right?
Right.
They're the legislature. They're the ones that make those decisions. So you can't ask for a writ of mandamus to say, Judge, we want you to find these 3 individuals guilty of ethics violations because they didn't. That would be a separation of powers issue.
Right.
You understand the difference? Mm-hmm. That's not what we're asking for. We're asking for this judge to order them to do their job, to review these cases minus Mr. Albritton because of his ethical ignorance, for lack of a better word.
And his current situation.
Okay, so the separation of powers thing is really infuriating, and I can't believe they threw it in there because...
Oh, I can.
I just steel manned it and straw manned it. I mean, I don't think the judge is going to have a hard time grabbing the concept that this is not a separation of powers issue. The plaintiff claims for court costs and attorney's fees are barred by the doctrine of sovereign immunity. Well, maybe, maybe not. The plaintiff requests that the court issue a writ of mandamus directing the Alabama Ethics Commission to reopen ethics complaints filed by Francis Paul Ripp against the following individuals: the Fairhope Airport Authority, Jack Burrell, Ray Hicks, North Baldwin Utilities, Robert Wills, and James Robertson, Fairhope City Council Robert Brown. Number 4, the plaintiff has no legal right to have the complaints he filed investigated. Can you believe they put that in a pleading?
Yeah, I mean, well, I'm a citizen.
You have no right to have these complaints investigated. All complaints filed with the commission that comply with the requirements of 3625-4D are evaluated to determine whether the complaint alleges facts, which, if true, would constitute a violation of the Ethics Act or the Fair Campaign Practices Act. We don't care about that. And whether there's a reasonable cause to conduct an investigation. So here's where they bury themselves. Prior to the commencement of investigation, the commission shall receive a written and signed complaint against a respondent and the factual allegations which support such charges. Number 2, the director shall conduct a preliminary inquiry in order to make an initial determination that the complaint on its face alleges facts which, if true, would constitute a violation of this chapter or the Fair Campaign Act. And the reasonable cause exists to conduct an investigation. If the director determines that the complaint does not allege a violation or reasonable cause does not exist, the charge shall be dismissed, but such action must be reported to the commission. The commission shall be entitled to authorize an investigation upon written consent of 4 commission members upon an express finding that probable cause exists that a violation of this chapter of the Fair Campaign Practices Act have occurred. So,
why would they even look into it if he's already dismissed it?
Yeah, and we'll get to that in my response. So the plaintiff's baseless assertion that the director Albritton's disregard complaints filed by the plaintiff are irrelevant, even if true, as every case that is dismissed under the preliminary inquiry is reported to the commission. If the commission disagrees with the director's decision to dismiss a case after a preliminary inquiry based on a failure to allege a violation or present reasonable cause, the commission may authorize an investigation upon written consent of 4 commission members. Therefore, the decision to dismiss a complaint received by the commission ultimately rests with the commission, regardless of whether an investigation occurs. It's a beautiful thing, isn't it? So number 6, the plaintiff has ample means of other adequate remedies. The plaintiff claims because of the limited and exclusive jurisdiction of the Ethics Commission, the plaintiff's unaware of another remedy at his disposal. While the Ethics Commission's jurisdiction is extremely limited in scope as to what matters it is permitted to investigate, its jurisdiction is far from exclusive. The enforcement of this chapter shall be vested in the Commission, provided, however, nothing in this chapter shall be deemed limited or otherwise prohibit the Attorney General or the District Attorney for the appropriate jurisdiction from enforcing any provision of this chapter as they deem appropriate. Therefore, the Ethics Commission has concurrent jurisdiction over the enforcement of the Ethics Acts with both the Attorney General and every District Attorney in the state of Alabama.
Oh, well, that's laughable.
If the plaintiff disagrees with the Commission's decision to dismiss the complaint, he is welcome to contact the Attorney General or the appropriate District Attorney to file his complaint.
Which we did with no answer.
Okay, well, it's not important. I mean, I've got a real good response to it. We'll get to it. So the plaintiff is unable to show an imperative duty upon the respondents to perform, accompanied by a refusal to do so, except for the documents that we gave the court, where we said, hey, they did this, and they said, hey, we're not looking into it.
Right.
The Ethics Commission received the plaintiff's complaints, evaluated the complaints, and dismissed the complaints either before or after investigating the conduct alleged as required by the code. That the Ethics Commission is prohibited from providing the complainant, meaning you, Mr. Ripp, or any other member of the public, with any information about a matter, including an investigation that may have occurred where the complaint is dismissed or found not to have had probable cause other than the disposition of the matter. The complainants filed by the plaintiff were all dismissed per Alabama Code Section 3625 4.1. This is the only information about the complaints that the plaintiff is entitled to receive, and the commission is not permitted to provide the plaintiff with any other details about the matter, even though you're the guy that complained.
Right.
The plaintiff has failed to show that there has been a clear abuse of discretion by the Ethics Commission in dismissing the complaints, even though they said they don't have to tell you why they dismissed it, nor have to disclose anything about it. But because of all that, you can't prove that they didn't do their job somehow. The plaintiff neglects to address how the complainants allege a violation of the Ethics or Fair Campaign Practices Act and show reasonable cause that a violation of ethics has occurred, except for the,
documents.
Yeah. So anyway, these are this is inside counsel. The Alabama Ethics Commission actually has their own lawyers, and then I saw Thursday an assistant attorney general is also going to be helping them defend Mr. Albritton tomorrow.
Oh, that's going to get
notice
interesting.
Of appearance.
So what he did is okay. Well, we're going to see whether what he's doing is okay, right?
Yep.
If what he's doing is okay, it kind of changes everything.
So here's my response to their motion to dismiss. Comes now the plaintiff by through his attorney of record and files his response to the defendant's motion to dismiss for lack of subject matter jurisdiction and failed to state a claim upon which relief can be granted, and in support of the same states as follows: the defendant's feeble attempt at making this a constitutional issue falls short. The courts in Alabama have issued writs of mandamus directing judges, sheriffs, state administrative agencies, and any other number of public officials or public employees who have acted or refused to act in a manner that meets the requirements detailed in our original pleading. Remember those? Yep. Yeah. Plaintiff is not asking the court to make a final determination in this matter regarding the guilt of the respondents to his ethics complaints, nor is he asking the court that the court supplant the commission's decisions in the following cases. And I list them again. Because Mr. Albritton's own ethical conundrum related to the Mabel Amos Scholarship Trust and the fact that the defendant's own motion to dismiss details his intimate involvement with the procedures of preliminary investigations, decisions related to investigating or closing the matter, we have asked the court to order the Ethics Commission to review these three specific complaints without Director Albritton's input. The commission would lead you to believe that because they are notified of Director Albritton's decision to close a reported case and that they have the ability to override his decision by a supermajority vote, that they have the last word. It is hard to imagine that the commission would come to this conclusion when all of the information given to the commissioners is filtered through Albritton and his staff. The Ethics Commission would be suspect indeed if they, part-time volunteers, did not listen to their director and take his lead in matters that come before the commission. Absent his involvement, Mr. Ripp believes he would get a fair investigation into these three specific complaints properly filed under the code. Your plaintiff is aware of concurrent jurisdiction of the Attorney General and the District Attorneys in the applicable jurisdiction. Please see Exhibits 1 through 5, and those
right.
It's a ream of paper, believe me. As the court is aware that the Ethics Commission investigates and then notifies the proper law enforcement agency for prosecution when the commission's good works have been concluded. It would not be improper for a local district attorney nor the Attorney General to further investigate a matter that violated the ethics law. They are notified of and charged with prosecuting. Mr. Ripp is not a district attorney nor the Attorney General, but followed the code in bringing these issues to the attention of the proper authorities, the Alabama Ethics Commission, who refuses to perform their legal obligations under the code. Your plaintiff has an ethics complaint against the Ethics Commission Director Thomas Albritton related to the Mabel Amos Scholarship Trust. Mr. Albritton's defense to these allegations was to simply state that he did not vote on the matter, awarding his children over $100,000. Now that the Ethics Commission is aware of Mr. Albritton's position on the vote abstention defense, it would be improper for him to be involved in any such cases going forward where the vote abstention defense is invoked by a respondent. Mr. Ripp is simply asking for Mr. Albritton to be removed from the process. Therefore, the premise is considered. The plaintiff prays the court will conduct an emergency hearing and issue a written mandamus directing the Alabama Ethics Commission to reopen these specific ethics complaints herein filed by Francis Paul Ripp and further order that Director Thomas Albritton have no input or supervision over these specific ethics complaints. And on that one, I'll drop the mic. Let you guys talk about it.
I thought it was very good. I understand it. I think it's pretty simple. I hope we don't get bogged down in a bunch of legal minutia, which I think we will. I think it's interesting that the Attorney General is going to have an attorney there when we complained to the Attorney General and didn't even get a response to our letter.
Yeah, maybe he'll read the letter you sent him 2 years ago.
Right. And the one that we produced over the Robert Brown case, we never got a word on that one either. So we'll see. We'll have to just see what happens tomorrow. I'm like I said, I'm going to be a little bit pessimistic, but we'll be certainly coming back and letting all our listeners know exactly what happened and where this is going. Pardon me.
So what do you think, Raines? You heard both sides
I think
of
you
the
got
argument.
a good shot at it. I think you got a good shot at it. I'll be anxious to see what comes out of it tomorrow. As Harry and I talked over the weekend, I hate that this is an all or nothing kind of thing, and that if they find one single fault with any single issue,
right,
that they can just dismiss the whole thing. But that's that's the system, and we have to work within the system until we don't. So
until we don't.
I'm very, very interested to see how this turns out. I will be pushing the results of this hearing on every branch of social media I own.